When we first started talking about this issue today, I was reminded of a conversation I actually had with a property lawyer many years ago when this question came up, Wendy, of what you cannot remove from a home. And his answer, I've never forgotten, was that if you took the house off the ground, turned it upside down and shook it, everything that fell out could be moved out with you, and everything that stuck had to stay in the home and be left behind. And this is exactly the issue we're discussing today.
It is the issue. My one has been, if you need tools to remove it, it is a fixture, and don't do it. But I think we're going to have someone far more qualified than us to talk about that, an attorney. When you buy a house, you are entitled to receive the property with all physical improvements of a permanent nature, permanent being the operative word, as well as all items which are permanently attached to the land or to the building, or should be permanently. As I say, if you need to take your tools to it, then you're doing the wrong thing. Unless it's specified in the contract, of course, that the buyer negotiated or the seller negotiated that this is of particular sentimental value or whatever, a wedding present, for example, of a light fitting, and they want to take it. And then you can negotiate, okay, well, this is what you can replace it with this. And as with everything we discuss on this feature, communication is absolutely key. Right, so a common law principle in our law provides that everything attached to the land effectively becomes part of the land itself. But with many house sales, disputes arise over which movable items have been attached to the property to the extent that they are regarded as forming part of the property itself and therefore included in the sale. So it could have been the beautiful established garden, which was the deciding factor for a buyer, but in the seller's mind, the most special plants that they've lovingly nurtured over years are theirs for the taking and the transplanting. And that could make for a bit of a horrible shock on moving in day for the buyers. Or it could be the built-in braai, or, as I said, something like a very sentimental light fitting.
Okay, so what is the disputed item in today's case study?
Okay, so in Craig's case, there were many bespoke features in the Tokai home, which he bought recently, that he really loved. But the prime one was, and the centerpiece of the home, was a custom-built unit, a huge one. I've sent you the photograph, Pippa. It covers an entire wall of the living room. Yeah. And Craig told us in an email, the listing which advertised the house as having custom built fixtures specified the unit, and the Rawson estate agent went out of his way to brag that everything was included.
I'm going to ask Rafik, my producer, to tweet those photos, by the way, at CapeTalk if you want to take a look and get a visual sense of what it is that we're discussing. So very clearly specified that it is custom built for this house and it is part of what is on sale.
Exactly.
Okay.
So in the email that Craig wrote to us, he said transfer was on the 30th of September and the sellers asked if they could stay for 2 more weeks because they weren't ready to move out. So I let them stay and I moved in on the 14th of October. But on that day, he found that wall stripped, repainted, not quite the same color as the other walls. I mean, even if you choose the same color, if there's been a few years in between the different batch, it's not going to match. And the quote he got to replace the unit, because obviously he had a photo of it from the listing, was around 100,000.
Ouch.
Rand.
Okay.
So this is a high-ticket item, and obviously the dispute is equally big and high.
Okay, now we've got Craig with us on the line. And Craig, thank you very much for being willing to chat to us today. Welcome to the show.
It's a pleasure, thank you.
How did it feel walking into your new home and being greeted by that blank wall where once there was that beautiful custom-built shelving that was such an appealing thing to you?
Yeah, it's quite sickening. It's not the best feeling. You know, moving houses is always incredibly stressful, but you know, it's an amazing house, and I was really excited to move in. And it's the features what greets you as you walk through the door. And I walked through the door with the agent because he'd got the keys, and the first thing I saw was this 6 by 3 meter blank wall. And I looked at the agent and I saw his face drop, and he's like, "That's not supposed to be empty." And that was literally the first thing I saw when I walked in.
Oy.
Okay, so it's a massive piece of furniture, Craig, specifically made for that wall and attached to it. It wasn't specified in the sale agreement as a fixture, though. Could you explain the story around that briefly?
Sure. So, the listing actually specifies these custom features. And when I came for the first viewing, the agent, obviously went out of his way to go like, this thing's amazing. And it was built for this wall, which it was. He explained, I mean, I think, it was 160,000 Rand, which the seller has since confirmed because he tried to sell it back to me.
160,000 Rand, okay.
It was 160,000 Rand for this feature. And so he was like, and this all stays with the house, and he went through everything. Now, the unit matches the kitchen. So it's kind of, it's a mirror of the kitchen. So, and I would never have assumed it wasn't included because it was built wall to wall, floor to ceiling. The tiles have been cut to accommodate it like it's proper. Anyway, when we went through the whole thing and I was, deciding what, the specifications around what I wanted the guys to keep or include as part of the sale, I said, listen, what do we need to do this? And he said, no, that's a built-in, it's a fixture. You don't need to specify it. It has to stay with the home. And I said, okay, that's fine. So I didn't specify it. On their offer to purchase, there's a place where the seller can specify anything that they want to keep as a fixture, and that also wasn't specified. So it just wasn't spoken about.
Yeah.
What I can tell you though is I made my first offer. And they came back and it was rejected. And the agent went out of his way to use the fact that the price of this wall or the price of this feature and all the custom stuff, went out of his way to use that as justification for me to increase my offer to what the seller wanted, which I did.
Yeah.
And so to have it used as bait to get a higher offer and to arrive and it not be here is obviously like a big shock.
Absolutely sickening, I'm sure. So what did you, so you walk in with the agent says immediately that's not meant to be gone. They were, to be generous, probably taken aback if you take it on good faith that they didn't know the seller was taking it.
I think we can state that as
probably,
fact.
okay.
I've spoken to the agent.
Yeah. Okay.
Yeah.
All right. So both of you standing there with your jaws on the floor at what is what you were expecting to be there is not being there. What did you do next, Craig? What recourse did you try?
Well, I said to him, you need to get the wall feature back. And he was adamant. He said 100%, that shouldn't be gone. I'm going to speak to the guy. Don't worry, I'll get it back. Like, obviously, he was in shock. He genuinely was in shock as well. I don't think he wanted to have that experience for himself or for me. And so I kind of left. I was like, okay, fine, just get it back. And then it kind of went on, and the stories got longer and longer. And eventually I just realized that the seller had told him, no, he didn't deem it as a fixture. It wasn't actually screwed into the wall, and so that makes it movable, and he's not returning it. So like the seller just said, no, he's not returning it. We approached STBB, who are the conveyancing attorneys. They turned around and said, no, there's nothing they can do. It's not their problem. It's not, they can't act against their own client. And so I said to Rawson, I said, well, listen, you guys are going to need to figure out how to get this thing back. And they kind of turned around and said, no, it's not their problem either. It's between me and the seller.
Boy.
They're just agents. And so both STBB and Rawson kind of eventually just shrugged and went, we've tried phoning him. He's told us no, and it's on you now. So I had to send lawyers letters. I had to go to the expense of getting a lawyer to draft letters and send it through. The guy replied and basically said, no, it wasn't attached to the wall. It's not a fixture. So I'm not bringing it back. He did mail STBB and say it cost him 160,000 Rand to build it, and I can buy it back for 80,000, which STBB forwarded me. And I replied and I said, I've already paid for it. I'm not paying again.
Yeah. Plus the transport, which would have been significant. It needs a special truck and whatever.
Well, in my response to the seller, I said I'll pay for the transport for it to come back, but it has to be here. Like it is the feature of the house. It's what they use to sell the house.
Yeah.
But he's just doubled down. He's just like, nope, not happening, not interested.
Do your worst.
So, yeah, and so now my lawyers kind of turned around and said, well, he's not responding, and so the next step is to issue summons. And she's like, listen, like I have to get you to question this because it's a very lengthy and expensive process now. And I'm kind of sitting there going, like, there's nothing I can do now. Like you can sell a house, take anything you want out of it, and there's nothing anyone can do about it. That's the position I'm in. Unless I'm willing to spend 100,000 rand legal fees to get 100,000 rand covered back.
In the meantime, though, Wendy, you did take this up with Rawson Directory, who were the agents.
I did.
You had a discussion
I
with them.
invited, both the agent himself is mortified by the whole thing, and his superior, and I wanted one of them to come on the show, and they said they'd rather not. But I think it's important just to express what they told me off air. They said that this is the most severe case of fixture removal they've ever come across. The seller had accepted Craig's offer, the elevated offer. At no point was there ever mention of a side sale for the fixture or that it needed to be excluded from the sale, even after countless messages back and forth discussing other aspects of the sale. This was never mentioned. Says the agent. I was of the idea that we were on the same page. The seller was a difficult character, didn't respond to emails at all, said that straight out, and was difficult to get hold of. It's easy to avoid calls and WhatsApps and all the rest. He wanted to take the built-in bar, fridge and jacuzzi. So that will give you his idea of what he regarded as things that he could take. Although they're fixtures, and the agent was able to stop that from happening. He was told, the seller was, in no uncertain terms, that the wall unit in question was a fixture as well. He says we've as I've said, tried calling, WhatsApp's no response. We've emailed the attorneys who have also advised that they cannot get hold of him. Clearly, the seller is not interested in entertaining us and doesn't seem to care.
Yeah. Craig is going to stay on the line because I know he wants to hear the comments that are going to come from our next guest, who is a lawyer who will give us some insight into how the law views this issue. Tholakele Mrubata is an attorney and conveyancer with Norton Rose Fulbright, South Africa. And thank you so much for joining us, Tholakele. Welcome to the show.
Hi, Pippa. Lovely to be online with you guys.
Thank you. Okay, so Wendy, let me hand over to you to start the questioning.
Thanks. Hello, Tholakele.
Hi, Wendy.
What does the agent or the agency they work for, or the conveyancing firm rather, what if any liability do they bear or carry for the actions of the seller as the party which brokered the deal? I suspect you're going to say none.
So, Wendy, when it comes to liability, there's a number of aspects that we need to look into, and I'll try and be brief because of time. But what we need to start off with, we need to understand that the CPA provides that there should be no ambiguity or deception when goods or services are advertised for sale or promoted in any way. Therefore, the seller should always be aware of his actions and that they may be creating an expectation as to whether an item is included in the sale. If a property is advertised as having a bespoke furniture or bespoke furniture in general, it's not okay to sell that contrary to what was advertised. When it comes to liability, it depends on the circumstances of the matter. Should it be something that is quite material, then you could place liability on the agent and conveyancer for not handling the transactions as per the instructions that were given, as well as per the sale agreement. And we just need to remember that when it comes to transfer processes, there's a number of role players that are involved. You have the seller and the purchasers who have the obligations that arise from the sale agreement. Mm-hmm. You have the estate agent who plays a very important role in terms of ensuring that there's a meeting of minds or an understanding in terms of the sale agreement between the seller and the purchaser. At times, agents wear a hat as an agent for the seller and sometimes as an agent for purchaser. But in all instances, there should be consensus. The conveyancer is someone that has to ensure that the property registers. But now the conveyancer deals with the sale agreement that has been provided. So what is important when it comes to liability is that you need to look at the specific role player or all the role players and how they were involved in the transaction. And most importantly, the sale agreement dictates how the transaction should take place. So it would be premature to state that which role player has that specific liability. I've had a look at the pictures that you guys had sent through, and looking at it, you could say that that fixture had been one that is of a permanent nature, and the estate agent should have looked at it in such a way that he looked at the built-in cupboards as well in the bedroom.
Yes, so the agent said to me it wasn't. He didn't make a point of making it a separate specification because he said no more than he did with the built-in cupboards in the bedrooms or the kitchen cabinets in the kitchen. It's taken that's a fixture. Just something that came up during the show, which I wasn't specifically aware of. I was under the impression, I don't know why, that the units, although custom built for that wall, weren't actually physically attached to the wall, and that's what the seller is, and the odd at times that he's been able to be contacted, has said it's not a fixture because it's not physically attached to the wall. In this case, with a custom built piece of furniture that was advertised, listed as being part of the deal, does that make a material difference?
It makes somewhat of a difference, Wendy. When we look at the general rule in law, when a buyer purchases a property and becomes the owner of it, the permanent physical improvements, such as the buildings erected on the land, along with the items that are permanently attached to the improvements or buildings, are the purchasers as well once they purchase it. So the key thing here is of the permanent nature. Was that built-in unit actually of a permanent nature? Was it screwed in? So if we aren't able to ascertain that it was ascertain the nature of the item, the manner that it was attached to the property, and the intention of the owner, the fact that it wasn't actually attached to the property might leave some, room to say or to interpret that it wasn't actually a permanent fixture on the property in question.
Except for the fact that it was advertised as being so, and there was never any discussion around the seller taking it. Such a large piece, there would never be a discussion over a small little, cabinet. But this was, custom built. It's such an interesting case, and I think, like everything else we discuss in this slot, communication is key. Although I have a feeling, given what I've been told about the sale and the attempted removal of the jacuzzi as well as a built-in bath ridge, I have a feeling that these sellers might well have, no matter what was specified and discussed, might well have just seen fit to remove those cabinets or that unit anyway.
Yeah.
Tholakele, sorry, carry on. Answer first, then
Sorry, Wendy. I just want to specify how it's important that, when we speak about communication, in law, communication is, should be in writing.
Yeah, that's what I mean.
We understand that people have verbal agreements and so on, but if, that was supposed to be included, then that's something that has to be communicated. Again, we always go to consensus and the understanding of the agreement. All parties involved should understand that at the end of this transaction, all of us understand who is supposed to receive what. And I think in this instance, that's something that we need to pay attention to as well.
Yeah. Tholakele, several listeners are asking questions about items which might be disputable. So, for example, somebody says, what, for example, if it is a freestanding stove that isn't built in? Can the seller take that unit with them? And if so, would they need to put in a replacement, is one question.
So, again, we'd go back to the permanent nature. Was the stove attached to the property permanently? And if not, then the seller may take it. However, that's when you have to disclose things such as stoves. The stove will be an included item in respect of the sale agreement. So those things need to be specified. Other examples that people have disputes about would be your light fixtures, where people believe that you'd need to take a light fixture with you. But what is advisable is that you'd actually replace it before you place the property on the market if you feel as though that light fixture should be taken off.
Okay, that's very good advice.
One.
So if you know you're going to want to take a specific item that might be disputable, rather replace it with one you're happy to leave behind and avoid the problem. Peter asking, what about a flat screen television that's attached to the wall?
Again, you look at the nature. I'm guessing they have those rotatory ones where you can actually rotate it. Hey,
probably.
Yes. So you go back to the permanent nature. Yes, that is attached to the wall. You could say that it becomes part of the property in question. However, it is linked to the TV itself. The reason why he put it up there might be because the TV doesn't have a stand, and he wanted the TV to go up on the wall. And as such, he would want to take that with him. You could link this with an example of your pool cleaners, for example, where you would the pool serves the permanent nature. The pool cleaner serves the permanent nature of the pool, and as such, that would go with it at once. So I think that when it comes to a TV stand, that would also need to go with the TV when the seller moves out.
Okay. One from me. Satellite dishes. I remember earlier in the year speaking to a property attorney who said that can be a bit of a grey area, but to me that's very much a fixture. I mean, a seller can't unscrew the satellite dish, can they?
Mm-hmm. So when I look at it, it's not intended to be a permanent feature, as the owner would usually remove it with the decoder when he moves the property. When he moves property. So in this case, the movable item being the decoder cannot function without the accessory being the aerial. So if you leave with the decoder, you need the aerial as well.
So that's another one to specify, though, in your contract.
Yes.
So everyone knows.
Luckily for us, luckily for us, we're moving in times now where people don't really have a lot of aerials as well, with everything being online as well. So that also assists, I think.
It does, yeah. So in your experience and that of your firm, what other examples of this kind of fixture removals have you heard about or dealt with that have become, very acrimonious because of a lack of specification in the contract?
Yes. So one that I've heard of is one of bar stools, where you need to specify that the chairs are actually whether the chairs of the bar are actually included, especially when your chairs tie in with the theme of the bar. So, for example, you have a bar area that is of wood, the counters are the wood, and the bar stools actually match that theme. You need to specify whether those chairs will be part and parcel of the entire bar. And that was actually quite a tricky one. I wasn't aware that you'd have something like that, but that's something that people need to actually specify. Another one would be, for example, with your curtains. People take this lightly. So hanging by the hooks of rails or rods, or screws into the wall. The actual curtains can be easily removed as such and are usually considered as a personal property. However, the rails and the rod should be left in place to be given of a permanent nature. So that you won't remove. You take the curtain, but then you leave.
It's a good differentiator. Take the curtains, leave the rails. Yeah. And very interesting.
So a final question, Tholakele, before we say goodbye. We heard Craig's story and you've seen the photographs and obviously he's in a very difficult predicament because nobody seems able to sort of take the matter forward. What does a buyer do to protect themselves from arriving at their home and finding themselves in a position like Craig, that things they were expecting to be there have been taken away? What should you do to preempt getting into that situation?
So the first thing, I'll name a few things, Wendy. The first one is that the purchaser needs to scrutinize the agreement. And if you don't know how or where to even start with agreements of sales, you can approach a professional to assist you. That's one point of call. Do not sign an agreement if you feel that there are gray areas and if you're not sure of something that has to do with the fixtures or fittings. Secondly, when viewing the property, ask about features that you are unsure of and ensure that they are listed on the agreement. That's another way. Thirdly, keeping track of this transaction. This is where now the conveyancers and the estate agents would come in as well. When a seller moves out, the estate agent or the purchaser needs to be present to ensure that those objects that are included are actually left behind. So these things require more administrative work, but I mean, purchasing a property is a big investment for many people, and taking these extra steps could actually be beneficial, even though it requires more checks and balances from your side. And also just requesting constant updates from your estate agent. If there's no communication, approach the conveyancers as well and ask them for dates in which the sellers are moving out so that you can be present and you can ensure that all the properties are there. One other example that I have, this is in line with the seller, but it could be beneficial for the purchaser as well, is that when the seller can prepare a list of items which are to be included in the sale, and this would be prior to the listing of the property with an estate agent. And then this is encouraged. This is encouraged that this list forms part of the mandate of the agent in order to allow the agent the opportunity to point out the items which are to be removed by the seller prior to the registration.
That's great advice.
So in that way, you control things from your point of view, and you tell them from the onset, guys, this is how, these are the objects that I feel that will need to be included or excluded. And from the mandate onwards, there's a clear understanding. So if the purchasers in general can go about doing these 4 points, I think they'd be protected.
Tholakele Mrubata, thank you so much. Speaking to us there, attorney and conveyancer with Norton Rose Fulbright, South Africa. Thank you for your time.
Thank you very much, ladies.
And all the best to you. Right, Craig, listening into all of that, I don't know if that advice is going to be of any help to you in resolving your situation, but it certainly has clarified a few things on what to do if you ever go through this process again. Craig, just in closing, are you intending to pursue your own further legal action over this?
Yes, absolutely. I mean, it's going to, as I said, it's going to cost me 160,000 Rand to replace it, or I can spend 160,000 Rand legal fees and get it returned, or get a seller to do it. I can't let it go. I have to get it sorted. The one thing that wasn't addressed from a legal perspective is preparedness is obviously everything. But once you're in this situation, there doesn't seem to be. I was hoping there'd just be a simple, like you could go to a governing body and go, hey, listen, can someone just tell me if this is a fixture or not, and make a quick ruling. I don't know why it has to be such a burdensome experience or such a burdensome process to get the determination.
There isn't such a platform, and that I think you would have to your attorney, it would be his or her job to tell you, realistically what your chances are. I'm just thinking that it's such a large unit and made specifically for that wall in your beautiful home. What if it's in pieces now?
Short of building another wall to spec, how is he going to use it? It's a very strange situation.
Bloody minded thing to do.
It really does. Craig, I'm so sorry you've been through all of this, but thank you for joining us on the show.
And please keep us posted.
And please let us know what progress. Okay, good luck to you.
Thank you.
I really hope the next time we speak, it's to tell us that you've got your wall unit back, Craig.
Lunch with Pippa Hudson
on CapeTalk.